This is the brief on Title IX of the Philippine Revised Penal Code. These notes from Ateneo Law School's Ati Lorenzo U. Padilla detailed the strict laws protecting personal liberty, penalizing everything from physical captivity down to psychological intimidation. First, let's look at kidnapping and illegal detention. See, private citizens commit illegal detention, while public officers commit arbitrary detention. It's really all about intentionally stripping away someone's freedom to leave. Penalties max out for ransom, detentions over 3 days, or if the victim is a minor, female, killed, or raped. You might picture detention as locking someone in a box, right? But physical enclosures aren't actually required. Simply tying a child to a pillar restricts movement enough to count. Second, the law strictly protects our most vulnerable, minors. Special laws heavily penalize child trafficking and slavery, and abandoning a child under 7 is a severe crime. But what if a parent actually agrees to let their kid work off a family debt? Well, that's a hard no. The law totally overrides parental consent to prevent child exploitation. Finally, looking at psychological control and privacy, we have coercion and trespass. Grave coercion is using violence or intimidation to force someone to act against their will. Qualified trespass is violently entering someone's home. Think of vigilante debt collection. Can a creditor just forcefully seize a debtor's property? Absolutely not. Taking the law into your hands, even for a legitimate debt, is always a crime. So whether through physical locks, economic exploitation, or forceful intimidation, Philippine law severely punishes anyone stripping away another person's fundamental right to freely choose their own actions.
When a person is forcibly restrained and held against their will, the physical act looks identical across a variety of contexts. But in Philippine criminal law, that physical act is legally meaningless in a vacuum. The exact same method of physical restraint can result in a minor fine or trigger the death penalty. The outcome depends on microscopic variables like the clothes the offender is wearing, the duration of the confinement, and the identity of the victim. Articles 267 through 269 of the Revised Penal Code function as a rigid, interconnected decision tree. We use this matrix to map the statutory variables present in a case: the offender's status, the act's duration, and the true intent. Failing to establish the correct specific motive or circumstance in this matrix results in a fatal variance between the crime charged by the prosecutor and the facts actually proved in court. When that happens, the prosecution fails. The first statutory fork in the matrix evaluates the identity of the offender. If the offender is a public officer whose official duty involves detaining persons, the crime shifts entirely out of this chapter to arbitrary detention under Article 124. Jurisprudence provides a strict exception for public officers whose duties do not involve detention, like a sanitary inspector or a clerk. They are treated strictly as private individuals under the law. Once we are on the private individual path, we hit the second mandatory node, the specific intent to deprive liberty. Mere physical movement is insufficient. In People v. Soriano, constabulary agents moved a victim from a house to answer for a crime. The court ruled this lacked the specific motive of kidnapping because it was a matter of transit, not captivity. The statute requires actual confinement. In U.S. v. Cabanag, a girl was taken from her grandmother, but she was eventually allowed to return home alone. Because the victim retained the freedom to leave, the legal concept of kidnapping evaporates. The intent to confine is the absolute, non-negotiable prerequisite. Without it, the physical act of holding someone cannot mature into kidnapping. We now introduce the most severe element in the matrix. This condition overrides all other variables: ransom. Legally, ransom encompasses any payment or concession that releases someone from captivity. In People v. Kamad Akaran, the court established that forcing a victim to fulfill a promise to pay someone else's hospital expenses qualifies as ransom. The presence of a ransom motive immediately finalizes the crime as serious illegal detention under Article 267, regardless of how short the detention lasted. The statutory penalty for this override is death, as amended by Republic Act 7659, representing the absolute ceiling of Philippine penal law. There is a singular exception to this maximum penalty. If the offender is over 15 and under 18 years old, they are entitled to a privileged mitigating circumstance, lowering the penalty by 1 degree. The ransom motive acts as a legal accelerant. The law punishes the extortion of human life more severely than the simple restriction of movement. Returning to the main logic tree, if the ransom motive is absent, the law requires the act to pass through 4 specific statutory checkpoints under Article 267. Checkpoint 1 evaluates duration. The detention must last for more than 3 days. Checkpoint 2 examines the method of capture, specifically whether the offender simulated public authority to deceive the victim. Checkpoint 3 looks for the introduction of violence, including the infliction of serious physical injuries or direct threats to kill the victim. Checkpoint 4 analyzes the demographics of the victim. The charge escalates if the person kidnapped is a minor, a female, or a public officer. The statute applies an or logic. Satisfying any single one of these 4 conditions is enough to finalize the charge as serious illegal detention. This structure automatically maximizes protection for vulnerable demographics and severely punishes prolonged or violent restraints, even in the absence of an extortion motive. If a private individual illegally detains someone but fails all 4 tests of Article 267 and demands no ransom, the charge falls into a residual category. This is slight illegal detention under Article 268, the baseline charge for the simple deprivation of liberty. Article 268 includes a privileged mitigating circumstance. If the offender voluntarily releases the victim within 3 days and does so before criminal proceedings begin, the penalty is drastically lowered. We must also map a completely divergent motive. This occurs when the restraint is illegal, but the offender genuinely intends to deliver the victim to the proper authorities. In U.S. v. Fontanella, the accused tied the complainant up but immediately conducted him to the municipal jail. This conduct shifted the charge away from kidnapping to unlawful arrest under Article 269. Unlawful arrest is distinct from delay in delivery under Article 125. In unlawful arrest, the detention was never authorized by law to begin with, making the specific duration of the hold irrelevant. The law utilizes slight detention and unlawful arrest as calibration tools. They separate malicious kidnappers from overzealous citizens making unjustified arrests. This decision tree reveals the complexity of sorting one physical act into distinct crimes. Seeking profit triggers the ransom node, bypassing demographic and duration checks. A short, non-violent detention of an adult male filters past these severe checkpoints, cascading into slight illegal detention. The framework of crimes against liberty is structured as a hierarchy of intent and circumstance. Mastering criminal law 2 requires systematically isolating an offender's true authority, filtering for extortion, and weighing demographic vulnerabilities.
This video discusses kidnapping and serious illegal detention under Article 267 of the Revised Penal Code. This crime falls under Title 9, Crimes Against Personal Liberty and Security, Chapter 3, Crimes Against Liberty, Section 1, Illegal Detention. The penalties for these offenses range from reclusion perpetua to death, depending on the circumstances. Let us consider the elements of kidnapping and serious illegal detention. First, the offender must be a private individual. If the offender is a public officer, the crime committed would be arbitrary detention under Article 124 of the Revised Penal Code. The second element is that the offender kidnaps or detains another, or in any manner deprives him of his liberty. The intention to deprive another of liberty is essential to the crime of kidnapping. Detention or locking up of the victim is also essential. Actual confinement or restriction of the person of the offended party is required. There is no detention if the victim had the freedom to leave. Placing the victim in an enclosure is not required, as the deprivation of liberty in any other manner is sufficient. Restraint need not be permanent. However, restraint merely to prevent a victim from reporting a crime is not illegal detention. The third element is that the act of detention or kidnapping is illegal. The illegality of detention is understood to be included in the law. Detention is illegal when it is not ordered by competent authority or permitted by law. Finally, the crime is serious illegal detention if the kidnapping or detention lasted more than 3 days, was committed by simulating public authority, resulted in serious physical injuries or threats to kill, or the victim is a minor, a female, or a public officer, unless the crime was committed for the purpose of extorting ransom. Moving to qualifying circumstances, kidnapping or detention to extort ransom, even without the circumstances in the first paragraph of Article 267, is a qualifying circumstance. Ransom means payment that releases the victim from captivity and includes compelling the victim to fulfill a promise. Kidnapping or serious illegal detention is also qualified when the victim is killed, raped, tortured, or subjected to dehumanizing acts. In these cases, the maximum penalty imposable is death. It is important to distinguish illegal detention from arbitrary detention. Illegal detention is committed by private individuals and is a crime against personal liberty and security. Arbitrary detention is committed by public officers and is a crime against the fundamental laws of the state. Let us consider the complex crime of kidnapping with murder. If the victim was killed because of refusal to pay ransom, kidnapping can be a necessary means to commit murder, thus resulting in a complex crime, applying Article 48 of the Revised Penal Code. However, there are conflicting rulings on this matter. Kidnapping or serious illegal detention that results in the victim being killed, raped, tortured, or subjected to dehumanizing treatment is a special complex crime, as ruled in People v. Santos and Canosa. The complexity of kidnapping with murder depends on the purpose. If the victim was taken solely for the purpose of killing, and not for illegal detention or ransom, it may be considered a simple crime of murder, with the taking being absorbed. Now we will discuss slight illegal detention under Article 268 of the Revised Penal Code. Persons criminally liable include the principal, accomplices whose liability is raised to that of a co-principal, and other accomplices. The elements of slight illegal detention are that the offender is a private individual, the offender deprives another of liberty, the act is illegal, and the crime is committed without the attendance of the circumstances enumerated in Article 267 of the Revised Penal Code. Article 268 covers slight illegal detention. This includes a privileged mitigating circumstance where the voluntary release of the detained person, if not a female, minor, or public officer, occurs before the institution of criminal proceedings. To benefit from the privileged mitigating circumstance, the release must occur within 3 days of the detention's commencement and before any criminal proceedings are instituted. Furthermore, the offender must not have achieved the intended purpose of the detention. Next, we examine unlawful arrest under Article 269 of the Revised Penal Code. This crime is committed when an offender, who can be a public officer or a private individual, arrests or detains another illegally. Unlawful arrest by a public officer is distinguished from arbitrary detention based on the officer's authority and legal grounds for the arrest. A key element of unlawful arrest is the offender's purpose to deliver the victim to proper authorities. The duration of detention is not fixed, but the motive is controlling. If the intent to deliver the victim is absent, the crime becomes illegal detention. The arrest or detention must not be authorized by law, and there must be no reasonable ground for it. There is no unlawful arrest if the arrest is supported by a valid warrant issued by a court, as a proper warrant implies a legal basis. Unlawful arrest is distinguished from other forms of illegal detention where the primary purpose is to deliver the victim to authorities, but the detention is found to be unlawful. It is also distinct from delay in the delivery of detained persons, where the initial detention is legal, but the delay is the crime. The next topic is kidnapping and failure to return a minor under Article 270. This section is under Chapter 3, Crimes Against Liberty. Section 2, Kidnapping of Minors. This offense addresses two modes: kidnapping and deliberate failure to return a minor, or inducing a minor to abandon their home. The elements of this crime include that the offender is entrusted with the custody of a minor person, which is anyone under 18 years old. The offender may be the child's parent, though the penalty is reduced in such cases. Another key element is the offender's deliberate failure to restore the minor to their parents or guardian. Technically, Article 270 penalizes this failure to return, rather than the initial act of kidnapping a minor, which falls under Article 267. Articles 267 and 270 do not conflict, as Article 270 requires the offender to be entrusted with the minor's custody, unlike Article 267. However, the failure to return a minor under Article 270 may be included in the serious illegal detention of a minor under Article 267, as both involve deprivation of liberty. We are discussing inducing a minor to abandon home under Article 271 of the Revised Penal Code. This crime is part of Title IX, Crimes Against Personal Liberty and Security, specifically under kidnapping of minors. The elements include the minor living with parents or a guardian and being under 18 years of age, as per Republic Act No. 6809. Another element is that the offender induces the minor to abandon their home. The minor must leave due to inducement, not of their own free will. Inducement must be essential. Mere representations, such as praising a city, were held insufficient when minors were moved by their own spirit of adventure. The inducement must be actual, committed with criminal intent and determined by the will to cause damage. Mere inducement constitutes the crime, even if the minor's decision to abandon home is immaterial. The law aims to prevent the disruption of filial relationships and undue interference with a parent's right to custody. Under Article 271, the offenders may be the parents themselves, in which case the liability is lowered. Crimes covered should not be extended to unlawful arrest, but are limited to Articles 270 and 271. Presidential Decree No. 603, Article 160, penalizes inducing a child to leave custody, except in cases of grave physical or moral danger. Moving on to slavery, under Article 272 of the Revised Penal Code, a qualifying circumstance imposes a higher penalty if the purpose is to assign the victim to immoral traffic. The elements include the offender purchasing, selling, kidnapping, or detaining a human being with the purpose of enslaving them. This also applies when the victim is a child under Republic Act No. 7610. Employment or custody of a minor with the consent of a parent or guardian, even against the child's will, is not involuntary servitude. However, obliging another to render service as a servant without remuneration to repay a debt constitutes slavery. Slavery is distinguished from kidnapping or illegal detention by the purpose to enslave the victim. Republic Act No. 7610 penalizes child trafficking, which involves trading and dealing with children, including buying and selling for money or barter. The penalty ranges from reclusion temporal to reclusion perpetua. Exploitation of child labor, under Article 273 of the Revised Penal Code, concerns the retention of a minor in service against their will. Article 273 is not violated if the minor consents to the offender retaining their services. Exploitation of child labor is also present when the retention is under the pretext of reimbursing a debt incurred by an ascendant, guardian, or custodian. Indebtedness is not a legal ground for detention. The law intends to prevent this type of compulsory service. Next, services rendered under compulsion in payment of debts, under Article 274 of the Revised Penal Code. The elements are: the offender compels the debtor to work for him as a household servant or farm laborer. This includes being compelled to work as an office janitor. However, under Article 278, the service of a minor is not limited to household or farm work. A key element of Article 274 is that the compelled service is against the debtor's will. The debtor does not need to be a minor. The purpose of this compulsion is to require or enforce payment of debt. Article 274 differs from Article 273, as it involves compelling the debtor himself to render service, while Article 273 compels a minor for a supposed debt of a parent or guardian. Finally, we discuss abandonment of persons in danger and abandonment of one's own victim under Article 275. The first act punishable is failing to render assistance to a person found in an uninhabited place, wounded, or in danger of dying. This applies when the offender can assist without detriment to himself, and the omission does not constitute a more serious offense. The elements for the first act under Article 275 include: the place is uninhabited, the accused finds a wounded or endangered person, and the accused could have rendered assistance without detriment. Importantly, this is not applicable if the accused intentionally wounded the person in that place. The remaining elements of the first act are the accused failing to render assistance, and this omission not constituting a more serious offense. If an offender having custody of a minor fails to render assistance and the minor dies, it is treated as a graver penalty under Article 276. The second act punishable under Article 275 is failing to help or render assistance to another whom the offender accidentally wounded or injured. This is only applicable when the wounding or injury was accidental, not intended. The elements are the accidental wounding or injury and the failure to render assistance. The third act under Article 275 is failing to deliver an abandoned child under 7 years of age to authorities or family, or failing to take them to a safe place. The elements include the offender finding an abandoned child under 7 years old. Lack of knowledge regarding the child's exact age is immaterial. An abandoned child is understood to include a lost child, as they require the same protection. A second element is the offender's failure to deliver the child to authorities, the child's family, or a safe place. A safe place implies the child was found in an unsafe location. We now cover abandoning a minor under Article 276 of the Revised Penal Code. The penalty is simple, but qualified if the minor's death resulted from the abandonment, or if the minor's life was endangered because of the abandonment. The elements of abandoning a minor include the offender having custody of a child under 7 years of age and abandoning the child. The abandonment must be permanent, conscious, and deliberate. Momentary leaving is not sufficient. The law penalizes mere abandonment, even if the child's life was not actually endangered, as the interruption of care and protection is sufficient. Furthermore, the offender must have had no intent to kill the child when the abandonment occurred. Intent to kill is not presumed from the child's death in this crime. If there was intent to kill, the crime would be parricide, murder, or infanticide, rather than abandonment of a minor, unless a more serious offense is committed. If there was intent to kill but the minor did not die, the crime is attempted parricide, murder, or infanticide. Parents guilty of abandoning their children may be deprived of parental authority, requiring a judicial declaration. Presidential Decree No. 603 also penalizes the abandonment of a child that deprives them of necessary care and protection, as well as the sale or abandonment for consideration. Next is abandonment of minor by person entrusted with custody and indifference of parents, under Article 277. The punishable acts include delivering a minor to a public institution or other persons without the consent of the one who entrusted the minor, or the proper authorities. An element of this crime is that the offender must be charged with the rearing or education of the minor. Rear means to bring to maturity through education and nourishment. A person who finds a child but is not charged with their rearing or education may not be guilty under this article. The elements continue. The offender delivers the minor to a public institution or other persons, and the entrusting party or proper authorities have not consented. Parents or guardians may voluntarily commit a child to the DSWD or a licensed agency under Presidential Decree No. 603. Article 277 differs from Article 276. Article 277 applies to minors under 18 entrusted for rearing or education, where the minor is delivered to another person or institution. Article 276 applies to children under 7 years old, where abandonment results in a deprivation of care. The second punishable act under Article 277 is the indifference of parents, neglecting children by not providing the education their station and financial condition permit. This duty to educate terminates if the mother and children refuse to live with the accused without good reason. The failure to provide education must be a deliberate evasion of the obligation. If the failure is due to justifiable reasons, such as medical advice or loss of employment, it does not constitute a violation of Article 277. This offense requires the parent's station in life to require such education and their financial condition to permit it. This section covers criminal provisions under Presidential Decree No. 603 relating to the custody of children. Prohibited acts include a child leaving the person or institution under whose custody they were placed, under Article 160 of Presidential Decree No. 603. The penalties for these acts, as per Article 160, second paragraph, Presidential Decree No. 603, include imprisonment not exceeding 1 year or a fine not exceeding 2,000 pesos, or both. Deportation is an additional penalty if the offender is a foreigner. Next, we examine criminal provisions of Presidential Decree No. 603 regarding the education and rearing of children. Criminal acts committed by parents include neglecting a child's education based on the family's means and failing to enroll a child without justifiable reason. Other criminal acts include causing or permitting truancy, defined as absence without cause for more than 20 school days. The penalty is 2 to 6 months imprisonment or a fine not exceeding 500 pesos, or both. Moving to the exploitation of minors under Article 278 of the Revised Penal Code, punishable acts include causing any minor under 16 years of age to perform a dangerous feat of balancing, physical strength, or contortion. Exploitation also includes employing children under 16 who are not the offender's children or descendants in dangerous exhibitions such as those involving acrobats, gymnasts, or wild animal tamers, where the offender is engaged in a similar calling. Furthermore, it is an act of exploitation to employ any descendant under 12 years of age in the aforementioned dangerous exhibitions, provided the offender is engaged in one of these callings. Delivering a child under 16 gratuitously to a person following these callings, or to a habitual vagrant or beggar, is also considered exploitation, where the offender is an ascendant, guardian, teacher, or caregiver. The exploitation of minors also includes inducing any child under 16 to abandon the home of their ascendants, guardians, curators, or teachers, to follow a person engaged in the aforementioned callings, or to accompany a habitual vagrant or beggar. The purpose of inducement is critical under Article 278, Subdivision 5 of the Revised Penal Code. This contrasts with inducing a minor to abandon home under Article 271, which does not require a specific purpose. Additionally, the age limit differs between the two articles. Exploitation of a minor refers to acts endangering the minor's life or safety. Circumstances qualifying exploitation involve consideration of price, compensation, or promise, leading to a maximum period penalty. Employment of children below 15 years is allowed for light work under certain conditions. This work must not be harmful to their safety, health, or normal development, and must not prejudice their studies. Republic Act No. 7610 sets out requirements for child employment, including a work permit from DOL. The employer must ensure the child's protection, health, safety, and morals, and prevent exploitation or discrimination. DOL is mandated to issue implementing rules and regulations. Employment of children as models in advertisements promoting alcohol, tobacco, or violence is prohibited. Penalties for violations range from fines to imprisonment, including revocation of license for repeat offenses. Acts of child exploitation under Presidential Decree No. 603 are also punishable. This includes improperly exploiting a child for purposes like begging or other acts detrimental to their welfare, and causing or encouraging a child to lead an immoral or dissolute life. Hiring, employing, or inducing a child to perform in obscene exhibitions or shows is severely punished under Republic Act No. 7610. The penalty is prison mayor in its medium period, applicable to ascendants, guardians, or persons entrusted with the child's care who allow this. Republic Act No. 7610 also penalizes child prostitution and other sexual abuse, treating child prostitutes as victims rather than offenders. Child prostitution is defined as children engaging in sexual acts for profit or due to coercion or influence, where habitual behavior is not required. Persons liable for child prostitution include those who engage in, promote, facilitate, or induce it. This includes procurers, persons inducing clients, those taking advantage of influence to procure a child, and those using violence to force a child into prostitution. Liability also extends to those giving monetary or pecuniary benefit to a child to engage in prostitution, and persons committing sexual acts with exploited children. If the victim is under 12, prosecution is for rape or acts of lasciviousness under the Revised Penal Code. Additionally, persons deriving profit or advantage from child prostitution are liable. This includes managers or owners of establishments like bars, resorts, or saunas, where prostitution takes place, even if it is a cover for their licensed activity. Other acts of child abuse are punished under Article 59 of Presidential Decree No. 603, which criminalizes certain acts or omissions by parents concerning children. Republic Act No. 7610 also covers other acts of neglect, abuse, or exploitation that are prejudicial to a child's development. Attempted child prostitution is also penalized under Republic Act No. 7610. This occurs when a non-relative is found with a child in a room, inn, hotel, vessel, or secluded area, under circumstances suggesting the child is about to be sexually exploited. An attempt to commit child prostitution is also penalized when a person receives services from a child in areas of prohibition, such as a sauna parlor, massage clinic, health club, or similar establishments. The penalties prescribed for abandonment of helpless persons and exploitation of minors in Articles 275, 276, 277, and 278 of the Revised Penal Code do not prevent the imposition of penalties for any other felonies committed by the same person. This video covers qualified trespass to dwelling, defined in Article 280 of the Revised Penal Code, which also covers simple trespass. The penalty for simple trespass involves mere entry into another's dwelling against their will. Qualified trespass is committed through means of violence or intimidation, carrying a higher penalty. The elements of simple trespass to dwelling require the offender to be a private person. If the offender is a public officer, the crime is a violation of domicile. An offender may even be the owner if the entry is against the will of the actual occupant. A key element is that the offender enters the dwelling of another. Dwelling is defined as a building or structure exclusively used for rest and comfort, distinct from places for business or offices. Actual use is controlling, meaning a store or barn converted for dwelling use is considered a dwelling under Article 280. Dwelling includes a room occupied by another person, even within the same house. Entrance must be against the will of the occupant, meaning against presumed or express prohibition. Lack of permission alone is insufficient. Opposition to entry is required. Even a person previously denied entrance may suppose an absence of objection if they enter in utmost good faith. Generally, household members are presumed to have authority to extend an invitation to enter a house. Prohibition can be implied, such as entering a closed door early in the morning when occupants are sleeping, or entering through a window. Prohibition is also presumed regarding entry late at night after inmates have retired and closed their doors. Qualified trespass to dwelling involves violence or intimidation, resulting in a higher penalty. Intimidation refers only to persons. Examples include firing a revolver in the air to force entry, or flourishing a bolo against inmates upon gaining entrance. Intimidation may take place immediately after entrance. Violence can include entry after loosening door bars with a bolo or screwdriver. However, some jurisprudence suggests that violence does not refer to force upon things. Pushing a door violently and maltreating occupants after entering is an example where violence upon a person after entry is qualifying. Additional examples of violence include cutting a string fastening a door latch, which was considered an act of violence. Wounding the owner with a bolo after entry, even if not the means to gain entry, is still considered a qualifying act of violence. Article 280 protects the privacy of one's dwelling. Criminal intent is inherent in the unwelcomed visit of the trespasser. Trespass to dwelling can be a preparatory act to another crime, but if no overt act of the intended crime is committed, the offense is only trespass. Trespass to dwelling may be punishable separately from other offenses committed inside. If a person enters violently and commits other crimes like frustrated homicide, it is not a complex crime, but multiple crimes were committed. The purpose of entry is controlling. The provisions of Article 280 are not applicable in several cases, known as absolutory causes. This includes entrance to prevent serious harm to oneself, occupants, or third persons, or entrance to render service to humanity or justice. Entry into public houses while open is also excluded. Other forms of trespass are covered by Article 281 of the Revised Penal Code. This includes penalties and elements. The first element is that the offender enters the closed premises or fenced estate of another. Premises signifies a distinct and definite locality, which is fixed. The remaining elements of other forms of trespass are that the entrance is made while the premises or estate is uninhabited, the prohibition to enter is manifest, and the trespasser has not secured permission from the owner or caretaker. A warehouse is an example of a closed premise. Trespass to dwelling is distinguished from other forms of trespass by the nature of the offender and the place entered. In trespass to dwelling, the offender is a private person entering an inhabited dwelling house. In other forms, the offender may be any person entering an uninhabited closed premise or fenced estate. Other forms of trespass are covered by Article 281. Presidential Decree No. 772 penalized squatting, but was repealed by Republic Act No. 8368, without prejudice to Republic Act No. 7279 concerning, quote, professional squatting. Certain lands were excluded from the coverage of the repealed Presidential Decree No. 772. These exclusions include pasture lands and public agricultural lands, such as grazing lands, which are now punished by Republic Act No. 947. We now discuss grave threats under Article 282 of the Revised Penal Code. This article defines the penalty and acts punishable as grave threats. One act punishable as grave threat involves threatening another with inflicting a wrong amounting to a crime upon their person, honor, property, or that of their family, while demanding money or imposing a condition, even if not unlawful, and the offender attained their purpose. The elements of this first form of grave threats are an offender threatening another with the infliction of any wrong, the wrong amounting to a crime, and the threat coupled with a demand for money or condition. The attainment of the offender's purpose is a qualifying circumstance, not an element of grave threats. It determines the appropriate penalty, but the crime is still considered grave threat, even if the purpose is not attained. The second form of grave threat also involves threatening another with a wrong amounting to a crime and demanding money or a condition, but in this case, the offender does not attain their purpose. The elements for the second form are: the offender threatens a person or their family with a wrong, the wrong amounts to a crime, and a demand for money or condition is imposed, but the offender fails to achieve their purpose. In the third form of grave threat, the offender threatens another with a wrong amounting to a crime, but the threat is not subject to any condition. The elements for the third form include the offender threatening another with a wrong, the wrong amounting to a crime, and the threat not being subject to any condition. This form has a fixed penalty. Grave threats have qualifying circumstances, such as the threat being made in writing or through a middleman. The essence of the crime is intimidation, which is a promise of future harm. Grave threat is consummated as soon as the threat comes to the knowledge of the person threatened. However, threats made in connection with other crimes are generally absorbed by that crime. We continue with light threats under Article 283 of the Revised Penal Code. The elements include the offender threatening to commit a wrong that does not constitute a crime, demanding money or imposing a condition, even if not unlawful, and whether or not the offender attains their purpose. A key note is that the attainment of purpose does not affect the penalty for light threats. Light threats are committed similarly to grave threats under the first subdivision of Article 282, except the threatened act does not constitute a crime. Next is the bond for good behavior under Article 284. This bond covers both grave threats under Article 282 and light threats under Article 283. Comparing Article 284 with Article 35, Article 35 uses bond to keep the peace, while Article 284 uses bond for good behavior. Failure to provide a bond to keep the peace under Article 35 results in detention. In contrast, under Article 284, failure to give a bond for good behavior results in destierro. The bond for good behavior is considered an additional penalty, which the court may require. Moving to other light threats under Article 285. This offense includes acts like threatening another with a weapon or drawing a weapon during a quarrel, unless in lawful self-defense. This can be broken down into two acts punishable under the first subdivision of Article 285. The elements of this crime are that the offender threatens another with or draws a weapon. Additionally, there must be no quarrel provoking the threat, or if there was a quarrel, the drawing of the weapon was not in lawful self-defense. Another type of other light threats involves orally threatening another in the heat of anger with some harm constituting a crime without persisting in the idea. This is based on Subdivision 2 of Article 285. The first element for this type of threat is that the offender is in the heat of anger. Importantly, grave threats, if made in the heat of anger, may be considered other light threats, especially if there is no persistence in the threat. The second element is that the offender threatens another, and the third is that the threat involves some harm constituting a crime. The fourth element requires that the offender did not persist in the idea involved in the threat. The third form of other light threats involves orally threatening to do another any harm not constituting a felony. The elements include the offender orally threatening another, the threat involving some harm, and the harm not constituting a felony. In comparing Article 285 with Articles 282 and 283, threats under Subdivision 2 of Article 285 are similar to the third form of grave threats under Article 282, as the harm threatened is a crime. Threats under Subdivision 3 of Article 285 are similar to light threats under Article 283, as the harm threatened is not a crime. A key difference is that in other light threats under Article 285, there is no demand for money, no condition imposed, and the threat is not deliberate. Furthermore, light threats may be committed even when the person to whom it is directed is absent. We now discuss grave coercions under Article 286, as amended by Republic Act No. 7890. This act added threats or intimidation alongside violence as means for committing coercion. The modes include preventing another from doing something not prohibited by law, or compelling another to do something against their will. Qualifying circumstances for grave coercion include when it is committed in violation of the exercise of the right of suffrage, for purposes of compelling another to perform a religious act, or to prevent the exercise of such right or act. Coercion is considered consummated, even if the offended party did not accede to the purpose of the coercion. For example, maltreatment to compel admission of a crime constitutes consummated coercion, even if the agents failed to accomplish their purpose. The elements of grave coercion begin with the offender preventing another from doing something not prohibited by law, or compelling them to do something against their will, whether right or wrong. This includes coercion by prevention, like stopping someone from harvesting their crop, and coercion by compulsion. Prevention must occur at or about the time the offended party was doing, or about to do the act. Coercion by compulsion, the second mode, involves compelling someone to act against their will, often through violence and maltreatment. Compulsion includes the offender doing something himself while subjecting another to his will. Even without a legal right to a thing in another's possession, compelling them to surrender possession through violence is grave coercion, as no one is authorized to take law into their own hands. Prevention or compulsion must be effected by means of violence, threats, or intimidation, as added by Republic Act No. 7890. Violence means material force or a display of force intended to produce intimidation and control the offended party's will. Intimidation alone is sufficient, needing no actual physical contact. However, mere loud voice expressing intention to take possession, without an accompanying gesture of determination to use violence, is insufficient for coercion. Intimidation requires a display of material force, and mere appearance of armed men is not coercion by itself. Surrounding another in a notoriously threatening attitude is considered sufficient intimidation. Importantly, the violence or force used must be immediate, actual, or imminent for it to constitute grave coercion. Grave coercion includes acts done to prevent or compel something, whether it be right or wrong. However, if a creditor uses violence to seize a debtor's property for debt payment, the crime is only light coercion. The offender must also lack the authority of law or the right to perform the restraint. The element without authority of law means the absence of a lawful right or duty to prevent or compel. Note that a property owner loses the right to prevent interference if the interference is necessary to avert greater damage. Certain acts of prevention do not constitute grave coercion, but are covered by other crimes. Examples include interruption of religious worship, which is punishable under Article 132, and acts tending to prevent the meeting of Congress under Article 143. When there is prevention of a legislative body meeting, the crime is violation of Article 143, not grave coercion through arbitrary detention, even if compulsion and detention occur. Another crime is violation of parliamentary immunity under Article 145. Acts of compulsion that do not constitute grave coercion but another crime include compelling a person to change their residence, an act committed by a public officer under Article 127, and kidnapping a debtor to compel debt payment, which is kidnapping for ransom under Article 267. There is a right to prevent or compel when acting under lawful authority, such as a father disciplining an unemancipated son, or a tenant using self-help against dispossession. Similarly, there is a right to compel when in the exercise of a profession, like a doctor compelling an insane man to leave a cholera-infected house. Good faith can be a defense, as seen when a mayor authorized fencing a non-compliant barbershop, performing a duty to implement a health officer's recommendation. The law penalizes coercion to enforce the principle that no one can take the law into their own hands. Forcibly ejecting an occupant of bought land without judicial authority, or forcibly invading land claiming ownership, are considered coercion. Grave coercion is distinguished from illegal detention by the degree of confinement or restraint imposed on the offended party. Grave coercion is distinguished from frustrated illegal detention, as the latter requires actual confinement or restraint. Dragging an offended party a short distance may be consummated grave coercion, not frustrated illegal detention, unless the intent was actual confinement. The purpose of the confinement is key in distinguishing coercion from illegal detention. When the sole purpose of forcibly carrying away a victim is to compel them to proceed with a concerted marriage, the crime is grave coercion, not illegal detention. Grave coercion is also distinguished from maltreatment of a prisoner to extort a confession or information. If the offended party is already a prisoner, the crime is maltreatment of a prisoner under Article 235. However, if the offended party is not yet a prisoner, the crime is grave coercion. For instance, policemen dragging a suspected thief and hitting them to compel a confession are guilty of grave coercion, as the suspect was not yet officially a prisoner. We begin with light coercion under Article 287 of the Revised Penal Code. The elements include the offender being a creditor who seizes anything belonging to their debtor to apply it to debt payment. The seizure must be accomplished by means of violence or a display of material force that produces intimidation. This is a critical element, where the attitude of the offender is menacing enough to intimidate the victim. If the taking is achieved through deceit and misrepresentation, with the purpose of paying the debt, the crime may be unjust vexation rather than light coercion, especially if no violence is involved. The purpose of the offender must be to apply the seized item to the payment of the debt. Next is unjust vexation, considered another form of light coercion under the second paragraph of Article 287. It is defined as human conduct that, although not producing physical or material harm, unjustly annoys or vexes an innocent person. Grave coercion is distinguished from unjust vexation by the element of violence, which is present in grave coercion but absent in unjust vexation. Even if previous violence occurred, if the subsequent vexing act is independent and not characterized by violence, it is classified as unjust vexation. Article 288 covers other similar coercions, such as the compulsory purchase of merchandise and the payment of wages by means of tokens. The penalized acts involve forcing a laborer or employee to purchase goods from the offender. The elements of this crime include the offender being a person, agent, or officer of an association or corporation that employs laborers. The offender forces the employees to purchase merchandise or commodities from them or their firm. Another form of coercion under Article 288 is paying wages with tokens or objects other than Philippine legal tender currency, unless the employee expressly requested this form of payment. Chapter 4, Title 2, Book 1 of the Labor Code of the Philippines includes various prohibitions regarding wages. These include non-interference with the disposal of wages and prohibitions against unauthorized wage deductions and deposits for loss or damage. Article 289 addresses the formation, maintenance, and prohibition of combination of capital or labor through violence or threats. The elements involve the offender using violence or threats to compel laborers or employers in the free and legal exercise of their industry or work. However, peaceful picketing is not prohibited. The use of violence or threats by picketers may constitute coercion. The right to picket must be confined strictly to gaining information and peaceful persuasion, and does not extend to coercion and intimidation. The purpose of the offender in this crime is to organize, maintain, or prevent coalitions of capital or labor, a strike of laborers, or a lockout of employers. If the act constitutes a more serious offense, such as death or serious physical injuries, it should be punished as such. Preventing an employee from joining a registered labor organization is not punishable under the Revised Penal Code, unless done by a public officer. Working children have the same freedom to join unions, and neither management nor union should coerce them to join or withdraw membership. Unfair labor practices by employers or labor organizations that interfere with, restrain, or coerce employees' rights to self-organization are criminal offenses under the Labor Code. Prohibited acts related to strikes and lockouts may also be punished criminally if they constitute criminal acts. Finally, we discuss discovering secrets through seizure of correspondence under Article 290. The offender is a private individual or a public officer, not in the exercise of official function, who seizes the papers or letters of another. Seize means to place in someone's control or possession, and force or violence is not necessary. Taking possession, even for a short duration, is considered necessary for seizure, but voluntary delivery of a document is not seizure. The offender's purpose must be to discover the secrets of the other person. If a letter is opened by mistake, liability under Article 290 is negated. The offender must also be informed of the contents of the seized papers or letters, as the act of seizure must be driven by the desire to discover secrets. Prejudice is not an element of the offense. The qualifying circumstance to this crime is revealing the contents of the papers or letters. Article 290 does not apply to letters of minors or spouses, excluding them from coverage. This exclusion applies to parents, guardians, or persons entrusted with the custody of minors regarding their papers or letters, and to spouses regarding the papers or letters of either one of them. Next, we examine revealing secrets with abuse of office under Article 291, which outlines the penalty. The elements include the offender being a manager, employee, or servant who learns the secrets of their principal or master through this capacity. The secrets must be learned by reason of employment, coming to the offender's knowledge by reason of office or position. The crime is committed only if the offender reveals these secrets, as revelation makes the crime. Damage is not an element of this crime. We move on to the revelation of industrial secrets under Article 292, which also specifies a penalty. The elements require the offender to be a person in charge, employee, or workman of a manufacturing or industrial establishment. The offender must have learned of an industry secret of the establishment. This, quote, industry secret must refer to manufacturing or industrial processes that are not generally used. The crime is the revelation of such a secret, which may occur even after the employee has ceased their connection with the establishment, and prejudice must be caused to the owner. This video explores the architecture of boundaries under Title IX, focusing on crimes against personal liberty and security. We will use a rights-based master map to navigate these legal frameworks and their jurisdictional space, identifying critical legal exceptions and violations. Title IX is built on 5 pillars of protection: freedom of movement, protection of the vulnerable, human dignity and free will, sanctity of the home, and the right to privacy. Each pillar corresponds to specific articles within the law. Illegal detention, under Article 267, requires 3 core elements. The offender must be a private individual, there must be a deprivation of liberty, and criminal intent must be present. The deprivation of liberty does not strictly require physical enclosure, only denial of freedom to leave. This matrix helps diagnose different forms of illegal detention. Serious and slight illegal detention involve a private individual. Unlawful arrest can be committed by any person, while arbitrary detention is committed by a public officer without legal ground. Illegal detention can escalate based on aggravating circumstances. Tier 1 escalations lead to penalties like reclusion perpetua to death. Tier 2, triggered by demands for ransom or victim abuse, imposes the maximum penalty, death. Protecting minors involves multiple overlapping jurisdictions. The Inner Core, RA 7610, targets severe abuse and trafficking. The middle and outer shields address other violations, such as abandonment and neglect. This diagnostic flowchart clarifies abandonment and custody violations. The crime depends on the offender's relationship with the minor, distinguishing between those entrusted with custody and those who are not. It is important to distinguish between threats and coercion. Threats are the promise of future harm. Coercion is the present restraint of will, involving immediate or imminent violence to control the victim's actions right now. The anatomy of a threat is determined by whether the threatened wrong constitutes a criminal offense and if a condition was imposed. This diagnostic tree helps determine if the threat is grave or light, and the corresponding penalty. Coercion under Article 286 involves violence, threats, or intimidation, resulting in either prevention or compulsion. A critical caveat is that coercion evaporates if the offender has a lawful right to prevent or compel the act. This cheat sheet compares various crimes based on whether a future crime is threatened or if immediate force/violence is used, outlining the key defining trait for each offense, such as grave threats, light coercion, and unjust vexation. Trespass boundaries protect both the dwelling and closed premises or estates. Trespass to a dwelling requires entrance against the occupant's will. Trespass to closed premises involves entering uninhabited spaces without permission, where prohibition is manifest. The information vault covers discovery and revelation of secrets. This includes the seizure of correspondence, abuse of office by revealing secrets learned through employment, and the revelation of industrial secrets. Industrial coercion protects the labor boundary. This includes forcing laborers to buy from the employer, or paying wages in non-legal tender. Violence against labor combinations prevents organizing or maintaining labor coalitions. This master diagnostic map summarizes Title IX, helping determine the appropriate legal provision based on the primary intent or act of the offender, such as depriving liberty, controlling will, or targeting a minor.
Welcome to The Explainer. Today, we're unpacking the dense Philippine criminal law syllabus to figure out exactly how the justice system protects our most fundamental human freedoms. You know, we interact with the law every single day, mostly without even realizing it. We just assume our right to move freely, to feel safe at home, and to live without fear are just, well, natural states of being. But the reality is, those freedoms are guarded by a really intricate, fascinating web of legal definitions. So today, we're diving straight into Title IX of the Revised Penal Code, Crimes Against Personal Liberty and Security. Because legalese can get a little overwhelming, we're mapping out this massive syllabus through 4 distinct pillars of personal security: stealing liberty, protecting minors from exploitation, invading privacy through trespassing, and finally, stealing peace with criminal threats.
All right, let's jump right into Section 1, stealing liberty, specifically looking at illegal detention. Now, when we think of someone taking our physical freedom, our minds usually go straight to those dramatic kidnapping scenes from movies, right? But the law is way more nuanced than Hollywood. Let's challenge an assumption right off the bat. Drawing from a super interesting piece of jurisprudence, the case of People versus Ching Sui Siang. Imagine someone tells you that you absolutely cannot leave a room. They forbid you from even peeking out the window. Are you being illegally detained? You'd probably feel like you are. But in this specific case, there was no evidence that the doors were actually locked or closed to stop the victim from leaving if she really wanted to. So, here's the crucial takeaway. Actual confinement is an absolute must. If the door isn't locked and the supposed victim technically has the freedom to just walk out, the courts say that doesn't qualify as illegal detention. You see, the intent to deprive someone of their liberty has to be paired with the actual physical locking up or restriction of that person. A verbal command not to leave without any physical enforcement just doesn't cross the legal threshold. Now, this is where it gets kinda tricky. The law actually splits hairs depending on exactly who is committing the crime. If an everyday private citizen locks you up, that's illegal detention, a crime against personal liberty. But if a police officer locks you up without a valid legal ground, the charge changes completely to arbitrary detention, which is a crime against the fundamental laws of the state. And there's a brilliant little exception in the syllabus here. If a public officer whose job has absolutely nothing to do with detaining people, like, say, a sanitary inspector or government clerk, locks you up, they're treated exactly like a private citizen, and the charge reverts right back to illegal detention. Time also changes the whole nature of the crime. Once someone is unlawfully detained, the clock starts ticking. If that detention lasts up to 3 days, it's classified as slight illegal detention. But the very second that confinement crosses the 3-day mark, it legally escalates to serious illegal detention, which carries a massively severe penalty. So time literally dictates the weight of the justice brought down on the offender. But wait. Throw extortion into the mix, and that timeline goes completely out the window. It doesn't matter if you were held for 3 days or 3 minutes. The syllabus is clear. Demanding a ransom, and legally this even includes compelling a victim to promise to pay someone else's hospital bills, triggers the absolute maximum penalties under the law. The mere presence of extortion fundamentally alters the severity, often bumping it up to the maximum penalty of death under the code. And things take a really dark turn if a victim is killed because a ransom isn't paid. We see this in the landmark case of Parline versus Rodas, where we enter the stark reality of the special complex crime of kidnapping with murder. The court ruled that the kidnapping was basically a necessary means to commit the murder. The law recognizes that these aren't just two random, isolated events. They're intrinsically linked acts of supreme deprivation, and the legal system punishes them as one horrific complex crime. Okay, moving right along to Section 2, protecting minors from exploitation. The law recognizes that children simply cannot consent to the deprivation of their liberty, so the rules here become fiercely protective. Take the specific case of U.S. versus Peralta, which reminds us that physical restraint doesn't have to be permanent to be highly illegal. In this heartbreaking case, a 2-year-old child was tied to a wooden pillar. Why? Just to force the child's older brother, who had run away, to come back and work for the offenders. The temporary nature of tying up the toddler didn't save the offenders at all. Using a child as a literal tether is blatant, illegal detention. And the Penal Code casts a huge net to protect youth. It heavily penalizes anyone who uses a parent's debt as an excuse to keep a minor working for them, which the law basically views as a form of slavery. It's also a severe crime to actively convince a minor to run away from home. Interestingly, if you're entrusted with a minor's custody and you deliberately fail to return them, that is treated with almost the exact same gravity as kidnapping. The law isn't just protecting the child's physical freedom, it's protecting the sanctity of their relationship with their parents. Let's shift gears to Section 3, invading privacy, specifically looking at trespassing. This pillar shifts our focus from our physical bodies to the sanctity of our homes. We all want to feel safe behind closed doors, right? But what exactly defines trespassing? Well, when someone invades your home against your express prohibition, it's trespassing. Simple trespassing is when someone enters against your will, like slipping through an open door when you've told them to stay out. But qualified trespass involves force, and the way the law defines force might actually surprise you. Check this out. It brilliantly illustrates how strictly the courts define violence. In U.S. versus Lindio, the court decided that violence doesn't even have to mean attacking a person.
Applying force to objects, like loosening door bars with a screwdriver, or in this specific case, just cutting a tiny little string that was holding a door latch closed, totally qualifies. Just the sheer act of defeating that physical barrier, no matter how fragile it is, elevates the crime to qualified trespass. Now, the law isn't totally unbending. It provides exact exceptions known as absolutory causes. Basically, you can legally trespass if you're actively preventing a serious crime, saving someone from harm, or doing a service to humanity or justice. Like breaking down your neighbor's door because their kitchen is on fire, not a crime. Also, walking into a cafe or tavern while it's open for business can never be considered trespassing since the invitation to the public is just inherently presumed. And that brings us to our fourth and final pillar, stealing peace through criminal threats. Here we're looking at crimes that don't steal your physical liberty or your space, but they steal your mental peace. The core of this crime is intimidation, the promise of future harm. The penal code categorizes your fear based on exactly what action is being threatened. If someone threatens you with something that is legally a crime, like promising to commit arson or murder, that's a grave threat. But if they threaten you with something that does not constitute a crime, like threatening to expose a deeply embarrassing but legally acquired secret just to ruin your reputation, that gets classified as a light threat. And slapping a condition onto a threat fundamentally changes everything. Let's say I threaten to burn down your house unless you give me 500 pesos. If I actually get the money, that is the first, most severe form of grave threat. If you call the police and I don't get the money, that falls to the second form. But if I just threaten to burn your house down purely to terrify you with absolutely no conditions or demands attached, that's the third form. The law meticulously scales the punishment to match the exact mechanics of the intimidation. And it's wild how fast this is consummated. The threat is real the second the victim finds out about it. In People v. Sion, the court ruled that an indirect challenge to a gunfight amounted to intimidation, even if the target wasn't in the room when it was said. As long as that threat makes its way to the victim and creates a genuine fear that the harm is going to happen, the crime of grave threats is fully realized. But the law does actually understand human nature and the reality of flared tempers. Say you get into a huge argument, and in a sudden, blinding flash of anger, you yell out that you're going to shoot the person. Normally, threatening murder is a grave threat. But if you immediately cool off, apologize, and you don't persist in the idea, meaning you don't go home to grab a weapon or keep harassing them, the law drops that classification down to an other light threat. It actually acknowledges the difference between a calculated campaign of terror and just a momentary, uncharacteristic loss of control. So after unpacking all these tiny legal hairs, from a 3-day clock escalating illegal detention, to the fact that cutting a tiny string on a door counts as violence, to the specific conditions attached to our mental peace, it really leaves us wondering just how fragile our everyday freedoms are. The law is a shield, for sure, but it's a shield forged from incredibly specific definitions. Understanding those definitions is literally the only way to know when your rights have been breached. So I'll leave you with this. Which of your personal liberties do you take for granted the most? And if someone slowly started to encroach upon it, would you know exactly when they crossed the legal line? Thanks so much for joining me on this explainer. Keep learning, keep questioning, and I'll see you on the next one.
Imagine you're standing in just a massive, completely empty field.
Okay.
You can walk to the left, you can walk to the right. I mean, you can break into a full sprint, or you could just sit down in the grass.
Sounds pretty nice, honestly.
Right. You feel completely, entirely free. But if you could suddenly put on a pair of magic glasses that let you see the world exactly the way the legal system sees it well, that empty field wouldn't look empty at all.
No, it really wouldn't. It would be crisscrossed with just thousands of invisible tripwires.
Exactly. Thousands of them. Every step you take, every single word you say, every door you close, it's all governed by this staggeringly complex, invisible architecture of rules.
And the wild thing is, we walk through that labyrinth every single day, right? Completely unaware of the walls around us until we, accidentally bump into one.
Yeah. Most of us think of freedom as this grand philosophical concept, like a poem or a feeling.
Yeah.
But the reality is that freedom is actually a meticulously categorized set of boundaries.
It's an architecture.
Exactly. And today, we are decoding those invisible tripwires. Okay, let's unpack this. We're going to look at the actual blueprint of human liberty to see exactly where your freedom ends and a literal crime begins.
I love that premise.
For this deep dive, we are pulling from some incredible source material. It's a detailed legal syllabus on criminal law, specifically looking at Title IX of the Philippine Revised Penal Code, which covers crimes against personal liberty and security.
Right.
And this syllabus is packed with some of the most shocking, bizarre, and just highly specific real-world cases I've ever read.
It really is. And, what we're going to explore is how the law defines all these different boundaries. Physical boundaries, spatial boundaries, psychological, and even informational boundaries.
Which is a lot to cover.
It is, but the fundamental challenge for any legal system, and we see this throughout the source material, is that it has to separate the physical act, like what a person actually did with their hands, from their mental intent.
The law essentially has to measure the invisible.
Exactly. It's not just what you did, it's why you did it.
So I want to start with the most obvious way someone's freedom is stolen, right? Physical restraint. Kidnapping.
The big one.
Yeah. When I hear that word, I immediately picture what we were just talking about. A movie scene. Someone tied to a chair in a dark basement. It seems like the most straightforward crime on the planet. You lock someone up, you're a kidnapper.
You'd think so, but the physical act is really only half the story here. The law actually looks very, very closely at who is doing the locking up.
Wait, what does the who have to do with it?
Well, under this specific part of the penal code, kidnapping is a crime committed by a private individual.
Okay, but what if a police officer locks me in a basement without a warrant or, any actual legal reason?
Yeah.
That is still kidnapping, right?
I mean, it's a very serious crime, but legally, it falls under a completely different classification. When a public officer who has the authority to make arrests detains you illegally, that's called arbitrary detention.
Arbitrary detention. Okay.
Yeah, because the logic here is that arbitrary detention involves an abuse of legitimate authority. The state gave that officer the power to arrest people. If they use it improperly, they're abusing their office. Kidnapping is a crime against personal liberty committed by a private citizen.
So the law separates the rogue cops from the civilian criminals.
Exactly.
But the source material notes this really wild exception to that rule. It says this distinction for public officers only applies if the officer actually has the authority to detain people as part of their everyday job.
Yes. That is such a crucial distinction. The text brings up this great hypothetical, like, what if a sanitary inspector or a filing clerk in a government office suddenly locks you in a room?
I mean, I'd be very confused.
Right. But legally, they cannot claim they're committing arbitrary detention because they have absolutely zero legal authority to arrest anyone in the first place.
Oh, wow. So because it's not their job to arrest people, they can't abuse that specific power.
Precisely. When they detain someone, the law essentially strips away their government title for that specific act. They are treated exactly the same as a random private citizen off the street. They're just a kidnapper.
That paints such a bizarre picture. Just someone yelling, "Stand back! I'm a sanitary inspector and you're coming with me."
It's absurd, right? But it highlights how the law categorizes not just the action, but the identity and the granted power of the person taking that action.
Right. But even beyond who is doing the kidnapping, I was really surprised by how much weight the law puts on what's going on inside their head, the intent part of it.
Oh, intent is everything. Without the specific intent to deprive someone of their liberty, the physical act of moving them or holding them down might be a totally different crime, or honestly, it might not be a crime at all.
Wait, really?
Yeah. There's this classic case in the sources that illustrates this perfectly. So the victim in this case was physically grabbed and literally dragged by the offender.
Okay, let me stop you right there. If someone grabs me and drags me against my will, I'm calling that a kidnapping every single time. My liberty of movement is completely gone.
Sure, colloquially, you'd call it that. But the court looked at the situation differently. They examined the timeline. From the exact moment the victim was dragged until some gunshots were heard shortly after, it was a very, very brief interval.
Just a few minutes or something.
Right. And more importantly, the offender didn't say or do anything to indicate some long-term plan to hold her captive for a specific purpose.
Wait, so because it was fast, because he didn't announce, like, I am taking you hostage, the law says it's not a kidnapping.
Exactly. I mean, it might be coercion or it might be physical injuries depending on what else happened during the dragging, but the court ruled it lacked the core element of kidnapping.
Which is what exactly?
Kidnapping requires a deliberate, willful theft of time and space. The offender must have the specific purpose of detaining the victim.
Okay, I think I see how that prevents the law from, like, turning every single physical fight into a kidnapping charge.
Yes.
Because if two people get into a brawl at a bar, right, and one person pins the other to the floor for 5 minutes, technically they've deprived them of their liberty to stand up and leave. But their intent is just to win a fist fight, not to take a hostage.
The law is very careful about that boundary. There's another case in the syllabus involving constabulary agents, basically a police force. They took a victim from a house because they wanted him to answer for the murder of some people who had disappeared.
So they forced him to come with them.
Right. But the court ruled they were not liable for kidnapping. Their methods might have been entirely flawed or, procedurally illegal, but their core motive was investigation. They lacked the specific intent to deprive the man of his liberty just for the sheer sake of deprivation or for ransom.
So intent is basically the invisible engine driving the whole thing.
It really is.
But let's talk about the physical reality of the confinement itself, because this is where the legal interpretation genuinely blew my mind.
Oh, I know where you're going with this.
The victim must actually be locked up or detained, right? And there is a real-world case here that completely flips how we think about being held against our will.
What's fascinating here is that the law has to deal with what we might call the illusion of confinement. In this specific case, the accused brought the victim into an agency and explicitly told her not to peep out of the window. They commanded her not to leave the rooms.
Psychologically, she is being completely controlled. I mean, she's been given a direct order by her captor that she cannot leave. She's trapped.
She felt trapped, certainly. But when the court investigated the physical environment, they found absolutely no evidence that the doors of the building were locked.
Wait!
Yeah, they weren't closed in any way that would prevent her from leaving if she had just decided to disobey that verbal order.
This is wild. So it's like building a giant fence around someone, but leaving the gate wide open. If I tell you, do not walk through that open gate, and you stay out of pure fear, the law says you aren't actually kidnapped.
The law demands actual physical confinement or restriction of the person for this specific crime. Because she retained the physical ability to leave because the doors were literally open, it didn't meet the legal threshold for detention.
But what about the threats?
The threats or commands used to keep her there might qualify as a different crime, like coercion. But the deprivation of liberty itself was an illusion. She was bound by words, not by locks. For an adult victim, psychological influence alone usually isn't enough to secure a kidnapping conviction under this specific article.
I have to push back on that, though, because what if the victim is utterly terrified? If someone has this menacing presence or implies a threat, an unlocked door is meaningless. A person might be too paralyzed by fear to even test the doorknob. It feels like the law is punishing the victim for not calling the bluff.
That's a very fair critique. But the law is trying to maintain a strictly objective standard here. Because if we allow, I felt like I couldn't leave to be the only standard for kidnapping, the potential for false accusations or misinterpretations just skyrockets.
Like feeling trapped in a bad conversation.
Exactly. Did you feel you couldn't leave a bad date? Or an overbearing boss's office? The physical lock provides objective, undeniable proof of the offender's intent to confine. However, the law does recognize that the capacity to overcome that illusion of confinement varies greatly.
Right, because the standard completely changes if the victim is a child. The text contrasts that open door case with another one involving a minor.
Yes. In that case, a child was left in the house of a grandmother. The child had what the law calls freedom of locomotion.
Meaning they could walk around.
Right. They could walk around the living room, play in the kitchen, move around the interior of the house without any physical restraints.
But they were still considered legally deprived of their liberty.
Because a child does not have the freedom to leave the house at will and just navigate the world, they can't walk out the front door, hail a cab, and go home to their parents. For a minor, the inability to leave at will, even without ropes or locked doors, constitutes a true deprivation of liberty.
So the law pragmatically adjusts its view of physical boundaries based on how vulnerable the victim is.
Precisely.
Speaking of things that are not what they seem, I was really struck by how the penal code defines ransom.
Oh, this is a huge misconception.
Right. Because we know kidnapping gets a much harsher penalty historically, even the death penalty, if the goal is extortion. But my idea of ransom is entirely based on Hollywood.
Briefcases full of money.
Yeah. A briefcase full of unmarked, non-sequential bills dropped in a garbage can at midnight.
The legal definition of ransom is far broader and, honestly, much more insidious. The Supreme Court laid this out in one of the cases. Ransom is essentially the payment or condition that releases a person from captivity. but it absolutely does not have to be cash delivered to the kidnapper.
In that specific case in the syllabus, what did they actually demand?
The kidnappers forced the victim to fulfill a promise to pay someone else's hospital expenses. That was the literal price of their release.
Right.
And the court ruled that this definitively counts as ransom.
So a kidnapper could say, I'm going to lock you in this room until you pay your own mother's medical bills. They don't pocket a single peso for themselves. The money goes straight to a hospital. And legally, that is still kidnapping for ransom.
It is, because the law is punishing the condition placed on human freedom. The crime is treating a human being's liberty as a bargaining chip for any financial transaction.
Oh, wow.
The identity of the beneficiary, whether it's the kidnapper's personal bank account or a charity hospital, is totally irrelevant. The offender has commodified someone's right to walk free.
That is fascinating. Okay, so if the mind is the engine of the crime, what happens when that engine suddenly changes gears mid-act?
What do you mean?
Well, we've been talking about the physical act of holding someone. But what happens when the deprivation of liberty intersects with death? Because reading the syllabus, the lines between kidnapping, motive, and murder get incredibly blurry.
They do. In criminal law, when two distinct crimes are intimately connected like that, the courts often have to deal with what is called a complex crime.
The sources highlight the complex crime of kidnapping with murder. And there's a case where a victim was killed specifically because they refused to pay the ransom demand.
Right. When you have a scenario like that, the kidnapping is considered a necessary means to commit the extortion, and the murder is the ultimate result of that extortion failing. So the crimes basically fuse together into a single, massive, complex crime because they are inextricably linked by that ransom demand.
But then the text contrasts this with cases that are ruled as simple murder. And this is where my head really started to spin.
It gets complicated here.
Because the ruling seems to be based entirely on what the offender was thinking before they even laid a hand on the victim. Take this one case. A victim was forcibly taken from their own house, dragged away to a secluded spot, and killed.
To any outside observer, that looks exactly like a kidnapping that ended in a murder.
Right. But the court ruled it was not kidnapping with murder. It was just simple murder. The kidnapping charge was completely absorbed. Why? Because the court determined that the offender's sole purpose from the very beginning was to kill the victim.
Exactly.
They had no intention of detaining the person for any length of time, and there was no ransom demand.
The doctrine of absorption is a really fascinating concept. The law protects different societal interests with different statutes. The crime of kidnapping protects your interest in liberty. The crime of murder protects your interest in life.
Right.
If an offender's singular overriding goal is to extinguish your life, the physical act of dragging you out of your house is merely the mechanism they are using to achieve the murder.
Wait, hold on. You're telling me if I drag someone out of their house against their will and kill them, the law actually cares whether I plan to hold them for an hour versus just killing them immediately? Dead is dead. Why does the sequence of my thoughts matter so much?
It matters immensely because the penal code doesn't just judge the physical outcome, it judges the mental journey that led to that outcome. If your only goal was murder, the momentary deprivation of liberty is just a step toward that ultimate crime.
So it just disappears.
The lesser crime of stealing their liberty is absorbed by the ultimate heavier crime of stealing their life. You are punished for the murder, which encompasses the violent taking.
So because I didn't want to keep them captive, I only get charged with the murder.
Yeah.
But contrast that with a situation where someone is taken, held in a safe house for 5 days, and then killed. Now what?
Now the court has to perform a kind of legal archaeology.
Legal archaeology, I like that.
They have to dig into the sequence of events to unearth the original intent. Did the offender intend to kill the victim from day one and just took 5 days to get round to it? Or was the original intent purely to kidnap and detain them, and the decision to murder them came later as an afterthought?
Like maybe because the victim saw their face or tried to escape?
Exactly.
The sources note that rulings have historically been very tricky here. In one case, a victim was taken and killed 5 days later, and the court leaned heavily on the kidnapping aspect, likely because the extended detention proved an intent to hold them captive first.
Yes.
But in another case, a victim was taken, bound, brought to a remote place, and killed, and it was held to be murder only.
The exact same physical reality a body found in the woods results in completely different legal classifications depending on a thought the offender had days earlier. It just shows how deeply the law cares about the why and not just the what.
We've been focusing heavily on adults who have their liberty stolen by force. I want to transition to a group of people who lack the legal capacity to even consent to their own liberty being restricted.
Minors.
Minors.
Yeah. When we shift the conversation to minors, the fundamental concept of liberty changes entirely. For an adult, liberty means being free from restraint. You can go where you want. For a minor, true liberty, in the eyes of the law, actually requires the protective custody of a guardian. A minor is not legally or practically capable of surviving completely untethered.
Which brings us to Article 270, kidnapping and failure to return a minor. What surprised me is that this law isn't necessarily about a stranger snatching a kid off the street.
No, it's often much closer to home.
The text points out that this covers a situation where an offender is actually entrusted with the custody of a minor, maybe a relative or a babysitter, and then deliberately fails to restore that child to their parents or legal guardian.
The crime in that specific scenario isn't the taking. The initial taking was completely consensual and legal.
Because the parents said, sure, watch my kid.
Exactly. The crime is the failure to return. The offender has deliberately broken that chain of protective custody that the child requires.
But then there's Article 271, inducing a minor to abandon home. And this is where the law runs headfirst into the reality of teenagers.
Oh, this is a classic case.
There's a case cited here where some minors left their homes in the provinces and traveled to the big city, Manila. They went because someone had been talking up the city, highly praising it to them, offering to take them, and promising them a great time.
You can imagine the parents were absolutely frantic. They claimed this person had criminally induced their children to abandon their home.
But the court dismissed it. They ruled it was not criminal inducement. The court literally wrote that the minors were simply moved by the irresponsible spirit of adventure commonly found in youth today.
I love that phrasing. The court drew a very pragmatic line between malicious manipulation and simply tapping into a teenager's natural wanderlust.
Right.
Mere representations praising a city or even offering to act as a guide do not cross the threshold of criminal inducement if the primary driving force is the minor's own desire to see the world. The law requires actual inducement committed with a criminal intent.
Meaning a deliberate will to cause damage to the filial relationship between the child and the parents.
Precisely.
But here's where it gets really interesting. How does a judge practically measure a spirit of adventure? It sounds so poetic for a legal ruling. It feels like the judge is just saying, look, kids run away. We can't put everyone who tells a teenager Manila is awesome in jail.
It is exactly that kind of pragmatism. Because if the law criminalized every uncle or older cousin who told a teenager about the excitement of the city, the jails would literally overflow.
True.
The court has to look at the power dynamic. Was the adult using coercion, deceit, or overwhelming influence to sever the family bond, or were they just a catalyst for a teenager who was already looking for the door?
There is a wild detail about this law regarding who can actually commit this crime. Parents themselves can be guilty of inducing a minor to abandon home against their own kids.
That happens more often than you'd think in custody disputes.
If a mother and father are separated, and one parent induces the minor to abandon the home of the other parent who has legal custody, they can be charged.
The core belief here is the sanctity of the legal custody arrangement. The state has determined where the child's protective boundary lies. If a biological parent without custodial rights disrupts that, they are committing a crime against the child's legal security.
The penalty might be lower, though. The text mentions arresto mayor, or a fine. Let's pause on that term. Arresto mayor. What does that actually mean in terms of jail time?
It's a specific classification of penalty in the Philippine Penal Code. Arresto mayor refers to a relatively short-term imprisonment. It ranges from 1 month and 1 day up to 6 months.
Okay, so not decades.
Right. It is distinguished from heavier penalties like prison correctional or reclusion temporal, which mean years or decades in prison. So a parent disrupting custody faces jail time, but it's measured in months, acknowledging the familial relationship while still punishing the disruption of legal custody.
Got it. Let's go to the darkest side of exploiting the vulnerable. Slavery and debt peonage, Articles 272 to 274. We tend to think of slavery as this ancient, abolished concept, right? Something from history books.
Yeah, unfortunately, it's not.
But the Penal Code keeps it very much alive in its definitions to combat modern iterations of it.
It is a sad reality that the mechanisms of slavery evolve, and the law has to specifically target those new mechanisms.
The sources bring up a really troubling case. An employment agency advanced the money for a girl's fare and her subsistence so she could travel to them for work.
Very common setup.
But then They refused to let her leave the agency until that debt was repaid. The court came down incredibly hard on this, ruling that indebtedness is absolutely not a ground for detention.
You cannot use a human being's physical liberty as collateral for a civil debt. It is a profound legal boundary. A debt is a civil matter. Liberty is a fundamental human right. They are completely separate spheres.
It goes even further in another historical case. Here, a servant was obliged to work without any pay until a debt she owed her master was completely settled.
The court called that exactly what it is, literal slavery. Obliging someone to render service without remuneration to pay off a debt is the definition of involuntary servitude. The master doesn't just own the debt on paper, they are actively attempting to own the person's time, sweat, and labor by force.
Jumping from debt slavery to another form of exploitation, the syllabus outlines Article 278, exploitation of minors. And reading this part felt like stepping into a time machine to like a 1930s traveling circus.
The language in the code is remarkably specific to a certain era, isn't it?
It's incredible. It is a literal crime, still on the books, to employ children under 16 as acrobats, gymnasts, rope walkers, divers, or wild animal tamers.
Wild animal tamers.
Yeah.
These laws were drafted during an era where traveling exhibitions and highly dangerous physical spectacles were common entertainment.
And child labor laws weren't what they are today.
Exactly. Child labor was heavily exploited in these unregulated environments. A child's developing body was put at immense risk for profit.
Imagine a modern police officer making that arrest today. You are under arrest for employing an underage wild animal tamer.
It sounds absurd now.
But beyond the circus acts, it also prohibits causing a boy or girl to perform a dangerous feat of balancing, physical strength, or contortion.
The law is trying to protect the physical integrity of a child from adults who want to profit off their potential injury. Today, obviously, child labor is governed much more broadly by modern labor codes and special laws protecting children from hazardous work environments in general.
Right, it's not just about tightropes anymore.
But these highly specific prohibitions remain in the Revised Penal Code. They freeze a specific historical anxiety right into the law.
We've been talking about crimes of action, right? Snatching someone, locking a door, forcing someone to work off a debt, making a kid walk a tightrope. These are all things you actively do to someone.
Yes.
But the text introduces a concept that I find deeply unsettling. The crime of doing nothing, where your failure to act becomes a crime against someone's security.
We are entering the realm of criminal omissions. The law generally punishes human acts, right? But in highly specific life or death scenarios, it punishes the failure to act.
Article 275. Abandonment of persons in danger. The law says if you find someone wounded or in danger of dying, and you can help them without detriment to yourself, you have to help them. But here is the massive catch that changes everything. It must be in an uninhabited place.
That geographical requirement is the entire hinge of the law.
So this is like a legally mandated Good Samaritan law, but it is geographically locked. I really need to understand how this plays out in reality.
Okay, give me a scenario.
What if I am walking through a crowded shopping mall? I see someone collapse, having a massive heart attack, clearly in danger of dying. I look at them, I shrug, and I just keep walking. I don't even call for help. Am I off the hook for this crime simply because a mall is an inhabited place?
According to the strict letter of Article 275, yes. You would not be guilty of the crime of abandonment of persons in danger.
That feels incredibly callous. Morally, it's repugnant. Why does the law care where the person is dying? Why isn't human life universally protected by a duty to assist?
If we connect this to the bigger picture, it's because the law cannot mandate universal heroism or enforce morality in every single situation. It has to balance the preservation of life against your personal autonomy, your right to simply mind your own business and go about your day.
Even if someone is dying.
In a crowded mall, the legal assumption is that someone else will help, or that professional help, like security or medics, is readily available. Your specific inaction is not the sole cause of their continued jeopardy.
Ah, okay. But if we change the location?
Exactly. If you are hiking in a remote, uninhabited forest and you stumble upon a bleeding hiker, the entire dynamic shifts. In that isolated scenario, you are literally their only lifeline to the rest of humanity.
Because nobody else is coming.
Right. The law recognizes that your presence is their only chance of survival. Therefore, the scale tips. The preservation of human life overrides your right to walk away.
And the law says you must help, unless it's to your own detriment, so I don't have to fight off a bear to save them?
Correct. The law doesn't demand you sacrifice yourself. But you must render reasonable assistance, making a tourniquet, going to find help, calling authorities if you have a cell signal. The geography dictates your level of legal responsibility because it dictates the victim's level of isolation.
That brings us to abandoning children, which has its own set of rules under Articles 276 and 277. Abandoning a minor under 7 years old.
This is a really heavy topic in the code.
The text discusses a case that establishes that simply leaving a child momentarily isn't enough to constitute the crime of abandonment. It has to be a permanent, conscious, and deliberate deprivation of care.
Right, the law isn't targeting a parent who leaves their sleeping toddler in a crib for 2 minutes while they run out to the driveway to grab the mail.
Nobody's getting arrested for that.
Exactly. It is targeting the conscious severance of the protective bond.
But the source material makes a crucial, very dark legal distinction regarding the outcome of that abandonment. If you abandon a child, and the child tragically dies as a result, your intent at the exact moment you walked away dictates your fate.
It goes back to measuring the invisible.
If you intended to kill the child by abandoning them, say leaving an infant in the freezing woods, you are not charged with abandonment. You are charged with parricide, murder, or infanticide.
In that scenario, the abandonment was merely the weapon you selected to commit the murder. Just as someone might choose a gun or poison, you chose exposure and neglect.
But what if you had absolutely no intent to kill? What if you left the child on the steps of a church, fully hoping and expecting someone would find them and take them in, but tragically, they die of exposure before they are discovered?
Then it is treated as a qualified, aggravated form of abandonment. The intent to kill cannot be automatically presumed just because the tragic result was death.
It has to be proven.
The prosecution bears the burden of proving you wanted the child dead, not just that you desperately wanted to be rid of the responsibility. It is a subtle line, but it determines whether you face the penalty for a negligent abandonment or the severe penalty for intentional murder.
There is another aspect of parental duty called the indifference of parents. It is actually a crime for a parent to neglect giving their children an education.
Under certain conditions, yes.
Right, there are caveats. It only applies if the family's station in life requires it and their financial condition permits it.
It is one of the rare instances in the penal code that explicitly ties a criminal obligation to a person's socioeconomic class.
And the text brings up a really heartbreaking defense in one specific case. A father was criminally charged because he stopped paying for his children's education.
Which looks bad on paper.
But the court investigated and noted that the father had recently lost his job, had absolutely no other means of income, and was under strict medical orders to rest due to illness.
The court ruled that his failure to educate his children was not a deliberate desire to evade his parental obligation. It was a physical and financial impossibility. He was not liable.
You can't squeeze blood from a stone.
The law demands responsibility from parents, but it does not demand the impossible. You cannot criminally penalize poverty or illness under the guise of parental indifference.
We've explored the physical body, we've explored the duty of care and omissions. I want to move to a completely different kind of boundary, the spatial boundary.
The home.
Yes, the extension of your personal liberty into the physical world. Where does public space end and your personal security begin? This is the crime of trespass to dwelling, Article 280. First, the law has to define what a dwelling actually is, and the rule is that actual use is controlling.
The physical architecture of the building matters far less than how the space is actually utilized by a human being.
The sources cite this case where a man has a store where he sells cheap goods. It's a commercial space. But he also sleeps in the back of the store. The court ruled this is legally a dwelling. The text even says a barn can become a dwelling, and a dwelling can become a barn based purely on whether someone is sleeping there.
It shows how the law defines the concept of sanctuary. A commercial space is open to the public. The expectation of privacy is extremely low. But the moment a human being lays their head down asleep there, the legal nature of that space transforms.
The tripwires go up.
The invisible tripwires around that building suddenly become much more severe.
It even applies to rented rooms, right?
Yes. Even a boarder's individual rented room inside a much larger shared house counts as their private dwelling. The perimeter of your liberty shrinks down to the door of your specific room. The landlord or the other boarders cannot cross that threshold against your will.
Okay, so you have established a dwelling. The crime of trespass happens when someone enters against the will of the occupant. But this is where the nuance is critical. A simple lack of permission isn't enough. It must be against a presumed or express prohibition.
This is a vital distinction for everyday life. If your front door is wide open in the middle of the afternoon and your neighbor walks in without asking to see if you have a cup of sugar, they haven't committed criminal trespass.
Even though I didn't say come in.
Right. They certainly lacked your explicit permission to enter at that exact moment, but you hadn't actively prohibited their entry.
But it gets complicated when you look at who can give permission. Look at this one case where someone enters a house because an inmate of the house invited them in. The catch. The person who extended the invitation was a 12-year-old child.
Oh, yeah?
The homeowner, the parent, was presumably furious that this person was in their house. But the court ruled that an invitation extended by a 12-year-old is sufficient to justify the entry. It wasn't trespass.
The law assumes that members of a household, even minors who have reached a certain age of reason, have the implicit authority to allow guests to cross the threshold. The intruder acted in good faith based on that invitation. From their perspective, there was no clear prohibition from the household.
So what does this all mean for modern life? If I leave my front door wide open and a stranger just walks into my living room, they aren't trespassing unless I explicitly look at them and say, "Get out."
Generally, yes, unless the prohibition is presumed or implied by the surrounding circumstances. The law doesn't require you to post an armed guard.
Right, the text breaks this down into implied versus presumed prohibition. For example, entering through a window. That is an implied prohibition. You don't build a window for guests to use as a door.
Hopefully not.
The very nature of the entry point implies you do not want people coming in that way.
And prohibition is presumed if it is late at night and the doors are closed. If someone turns the knob and walks into your house at 2 a.m., they cannot stand in your hallway and argue, "Well, there was no do not enter sign, so I thought it was fine."
That would be a terrible defense.
The time of day and the physical barrier of the closed door legally presume your opposition to visitors. The law respects the sanctity of the home, but it does require the homeowner to establish some baseline boundary of privacy. Closing the door at night establishes that boundary.
Now, what if the trespasser gets violent? That escalates the crime to qualified trespass. But there is a really interesting temporal trick here in how the courts view the timeline of the crime.
This timeline is key.
In one historical case, the trespassers gained entrance to a home. After they were already inside, they started flourishing a large machete at the people inside the house.
Right.
You might think, well, they didn't use violence to break in, they just walked in. So maybe it's simple trespass plus a separate assault charge?
But when you look at how the court interpreted that, they ruled it was qualified trespass. The law protects the conduct immediately after entry, not just the physical breaking of the lock. The violence relates not just to passing the threshold, but to the behavior inside the sanctuary itself.
But there are exceptions, right? Absolutory causes where you can legally break into someone's house without it being a crime.
Yes.
The text says you can trespass to prevent a serious harm to yourself or others. So if a bear is chasing me down the street, I can kick down your front door to hide, and I'm not a criminal.
I think the homeowner would understand.
Or I can break in to render a service to humanity or justice.
Yeah.
If I see your kitchen is on fire, I can smash your window to put it out. My violation of your spatial boundary is completely absolved by the preservation of a higher interest.
The law is rigid, but it builds in safety valves for common sense, emergencies, and human survival.
We've covered physical restraint, we've covered the duties of care, and we've covered spatial invasion. Now, I want to explore what might be the most insidious attacks on liberty, the psychological boundary.
This is where it gets really dark.
Hijacking someone's will through words, fear, and intimidation. We are talking about threats, coercion, and vexation. Let's start with grave threats under Article 282.
Okay.
A grave threat is threatening to do a wrong that amounts to a crime like "I'm going to kill you" and adding a condition to it, even a lawful condition. The text notes you can commit a grave threat by saying, "Marry my daughter or else I will kill you."
It sounds like a bad movie line.
Right. Asking someone to marry your daughter isn't an illegal request, but coupling it with a threat of murder makes it a grave threat.
It is the weaponization of fear. You are using the terror of a future crime to manipulate and control another person's present actions.
But there is a fascinating defense here. The lack of persistence. Look at this one case. Two people get into a heated quarrel. The accused threatens to kill the victim. He runs all the way home to get his revolver.
Which is an enormous escalation.
He comes back to the scene, actively looking for the victim. The victim is hidden. Later on, the accused calms down and apologizes. Because he did all this in the heat of anger and ultimately did not persist in the idea, his crime was actually downgraded by the court from a grave threat to a light threat.
The law is recognizing human frailty here. People say terrible, violent things in the heat of extreme anger. The court looks for a cooling off period. Did you maintain the psychological siege over time, or did the fever break?
So because he apologized, it's a lighter crime.
Because he didn't persist, yes. The law lessens the penalty, recognizing that his intent to truly control the victim's future was fleeting, driven by adrenaline rather than cold calculation.
But when that control is absolute and immediate, we move from threats to coercion. Grave coercion, Article 286. This is forcing someone to do something against their will or preventing them from doing something lawful by using violence, threats, or intimidation.
There is a horrifying case cited for this.
A taxi driver threatened his female passenger. He told her that if she didn't go to a nightclub with him, he was going to intentionally crash his car and kill them both.
The threat of mutual destruction, it is an overwhelming level of psychological intimidation.
The court ruled this was grave coercion. He didn't have to lay a single finger on her. The threat of immediate, violent death completely paralyzed and controlled her will. The fear took the place of physical violence.
It perfectly illustrates the concept of psychological imprisonment. She was as trapped in the back seat of that taxi by his words as she would have been if he had installed padlocks on the doors. Her liberty was entirely subjugated to his will.
On the completely opposite end of the spectrum of severity, but still falling under grave coercion, is a bizarre case. A woman was arrested by authorities simply because her servants had put stepladders out on the street to clean the outside of her house.
I remember this one. The arrest was completely absurd.
It had no basis in any local ordinances. The court ruled that the arresting officers themselves committed grave coercion. They used their authority and force to compel her against her will without any legal right to do so.
It shows that coercion scales all the way from the threat of murder down to the overzealous illegal enforcement of non-existent ladder laws. If you force someone's will without the authority of law, you cross the boundary.
Are there times I can legally force someone's will?
Yes, the law recognizes a right to prevent. For example, a parent can use reasonable force to prevent their unemancipated child from leaving home as a matter of discipline.
Unemancipated child meaning?
A minor who is still legally under the authority of their parents. Usually someone under 18 who isn't married or otherwise legally granted independence. The parents have a legal right and duty to control their movements for their own safety.
Are there other examples?
Another example is self-help. You can use reasonable force to stop someone who is actively trying to steal your property right in front of you.
Which leads to a very tricky distinction regarding property and debts. Light coercion, Article 287. Let's say someone owes me a lot of money. They refuse to pay. I'm sick of waiting. So I march into their house or their store and I forcibly seize their goods. Let's say I grab their brand new television to apply to the debt.
Don't do that.
In one historical case, a creditor forcibly took items from a debtor's store to settle the account. Wait, if someone genuinely owes me money and I just grab their TV to settle the debt, I am committing a crime, even if the TV is worth exactly what they owe me.
The court ruled in that case that the creditor was absolutely guilty of light coercion. He wasn't guilty of robbery because his intent wasn't to steal for personal profit. His intent was to settle a legitimate existing debt. However, you cannot take the law into your own hands.
There is a quote in the text from one of the rulings that sums this up. Ours is a government of law, not of men.
This raises an important question. If we allow creditors to become vigilante repo men, using violence or intimidation to seize assets whenever they feel wronged, we destroy the entire social fabric. We return to the rule of the strongest.
Right.
The law provides civil courts and legal processes to settle debts. Bypassing those courts through physical force is a crime against liberty, even if your underlying financial claim is 100% correct. You cannot coerce a settlement.
Under that same article is a fascinating catch-all crime, unjust vexation. It is defined as human conduct that unjustly annoys or vexes an innocent person. It doesn't have to produce any physical harm at all. The paramount test is whether the act causes annoyance, irritation, or distress to the mind.
It's a very broad definition.
In one case, a man kissed a girl and held her tightly. The court ruled that even if he did this without lewd designs, meaning the prosecution couldn't prove an intent for sexual assault or acts of lasciviousness, it is still a crime. It is unjust vexation. He profoundly disturbed her peace of mind.
Unjust vexation is the legal system's safety net. It is a way of sweeping up all the forms of psychological and physical boundary crossing that don't neatly fit the strict definitions of assault, threats, or coercion, but still unjustly disrupt a person's fundamental liberty to simply be left alone in peace.
We've talked about kidnapping the body, invading the home, and coercing the mind. Now we are arriving at the final frontier of personal liberty, the informational boundary, secrets and privacy.
This is more relevant now than ever.
Article 290, discovering secrets. This penalizes a private individual who seizes the papers or letters of another to discover their secrets.
But the nuance here is critical. The crime is not just the physical taking of the letter. The crime requires the specific intent to discover the secret, and you must actually be informed of the contents.
The text cites a great example. If I open a letter by mistake, say I grabbed the mail, I thought a letter was addressed to me, I tear it open, start reading, realize it is my neighbor's bank statement, and immediately put it down. There's no crime.
Because there was no intent.
Right. The seizure of the paper was not impelled by a desire to discover their secrets. My mistake completely negates the criminal intent.
It is the legal difference between a clumsy mail sorting error in your kitchen and deliberate corporate espionage.
Speaking of espionage, Articles 291 and 292 deal with revealing secrets. If an employee learns a secret by reason of their employment and reveals it, that's a crime. Or the revelation of industrial or manufacturing secrets to the prejudice of the owner. You can't take the Coca-Cola recipe from your boss and give it to a rival company.
Definitely not.
But I have to go back to Article 290, seizing private letters, because there is a massive, glaring exception written into this penal code. This law protecting your private papers does not apply to parents or guardians opening their minor children's letters.
That aligns perfectly with everything we've discussed about minors today. The parent has a protective mandate from the state that overrides the child's right to total privacy.
Okay, I understand the logic for kids, but the exception also applies to spouses. A husband or wife cannot be charged under this law for seizing and reading each other's private letters.
Yeah, that one usually shocks people.
Hold on. A husband can legally seize and read his wife's private letters. The law of liberty just stops at the marital bedroom door. I'm genuinely baffled by this. How has this not been struck down?
When you look at the historical and legal context of the penal code, much of it was drafted decades ago and relies on much older civil law traditions. Historically, the law defined the family unit, and specifically the marriage, as a singular, indivisible entity in many legal respects.
The concept of conjugal partnership.
Exactly. It blurred the lines of individual privacy between spouses.
But it treats spouses like they're one single organism.
Mm-hmm.
It completely erases the individual liberty of a married person when it comes to their own private thoughts and correspondence.
It does. The penal code assumes a level of shared life and shared secrets that makes criminalizing the reading of a spouse's mail unworkable or undesirable from the state's historical perspective.
Wow.
It treats the marital unit as a single sphere of privacy rather than two intersecting ones. It is a stark reminder that our legal map of freedom is deeply influenced by the cultural and historical eras in which the laws were originally written. The boundaries of individual autonomy evolve in society much faster than the text of a penal code.
What an incredible journey this has been. We have traced the invisible boundaries of human freedom from physical restraints to the secrets we keep on paper.
It's a lot to process.
We started with the physical chains of kidnapping, learning the counterintuitive reality that an unlocked door can legally negate a confinement, while forcing someone to pay a hospital bill counts as ransom. We explored the tragic intersection of kidnapping and murder, where the legal outcome hinges entirely on the sequence of a criminal's thoughts.
We navigated the complexities of minors, distinguishing between malicious inducement and a teenager's spirit of adventure. We looked at the dark realities of debt peonage and the archaic, highly specific laws protecting underage acrobats.
We ventured into the terrifying realm of omissions, where doing nothing to save a dying person in an uninhabited place becomes a crime. We mapped the spatial boundary of the home, learning how a store transforms into a sanctuary just by someone sleeping there, and how an open window legally implies a prohibition.
We unpacked the psychological warfare of threats and coercion, learning that you cannot bypass the courts to repossess a TV with your own hands. And finally, we explored the informational boundaries and the marital exceptions to privacy.
It really is a comprehensive map of human friction. The Penal Code attempts to anticipate every possible way one person can try to control, manipulate, or harm another.
It really is.
But I want to leave you with a final thought to ponder. If the law has to be this incredibly specific, defining everything from the unlocked door in a kidnapping to the exact age of a wild animal tamer to the exact intent behind a kiss in a moment of vexation, how much of our daily lived freedom actually relies on these laws?
That's the real question.
And how much simply relies on the unwritten social contract, the basic good faith, and the mutual respect of the strangers we share the world with? We walk through that field of invisible tripwires every single day, and most of us never set one off. Not because we have the penal code memorized, but because we just choose to treat each other with basic human decency.
The law is the ultimate safety net, but our mutual respect is the tightrope we actually walk on every day.
Thank you so much for joining us on this deep dive into the architecture of freedom. Keep questioning the boundaries around you, and we will see you next time.
Goodbye, and keep exploring.
Welcome to the debate. Imagine a terrifying yet very real scenario. A person is dragged from their home in the dead of night. They are bound, thrown into the trunk of a car, driven for hours to an isolated location, and then tragically, they are killed.
Yeah, an absolutely horrific sequence of events.
Exactly. And to anyone looking at that, two very distinct, very horrific crimes just occurred. A kidnapping followed by a murder.
Right.
But when we step into the courtroom and apply the strict mechanisms of the law, sometimes the legal system looks at those two acts, and by the time the gavel falls, the first crime has effectively disappeared.
It really is one of the most conceptually difficult areas of criminal law. I mean, you have the visceral physical reality of what happened to the victim on one side, and the cold structural framework of how we categorize criminal intent on the other.
Right. Today, we're diving deep into the Philippine Revised Penal Code, specifically looking at Title IX, which covers crimes against personal liberty and security.
And we're unpacking the profound jurisprudence surrounding the intersection of kidnapping and murder.
We are. The central question we have to wrestle with is this. When a victim is forcibly taken from their home and subsequently killed, does the act constitute a complex crime that recognizes the initial kidnapping?
Or does the ultimate intent to kill absorb that deprivation of liberty into the single crime of murder?
Exactly. To establish the sides here, I represent the perspective that kidnapping remains a distinct or complex harm based on the objective deprivation of liberty.
And I represent the position that the singular intent to kill absorbs the preparatory act of capture into simple murder.
Which really forces us to look at what the justice system considers the true foundation of a crime. Is it the physical mechanics of the action or the architecture of the perpetrator's mind?
I think that's the perfect way to frame it.
Let me jump right in and lay out my perspective, because I think we have to start with the objective reality of the harm inflicted. I argue for the recognition of distinct and complex crimes when a victim is moved or detained prior to a murder.
So, focusing heavily on the physical act itself.
Yes. We must emphasize the objective reality. If we look conceptually at the statutes, specifically Article 267 of the Penal Code, which defines kidnapping and serious illegal detention, the mechanism is quite clear. If a person is bound, if they are forcibly transported, their personal liberty has been severely violated.
Okay, but
to me, the moment that happens, the elements of Article 267 are completely fulfilled. The crime exists in the real world.
Even if their life is ended shortly after that, you don't view that movement as just part of the murder?
I don't, because the law shouldn't just erase trauma because a worse trauma followed. I look at the precedent set in the case of People versus Suarez.
Ah, yes.
When the court examined the facts of that case, they noted explicitly that in a kidnapping, it is immaterial that the victim was subsequently killed. The deprivation of liberty is a historical fact. Furthermore, let's look at the framework established in Parolon versus Rodas.
Right, where the victim was killed for refusing to pay ransom.
Exactly. In that scenario, the court recognized that the kidnapping served as a necessary means to commit the murder, thus applying Article 48 of the Revised Penal Code for complex crimes.
But, ransom introduces a totally different dynamic.
It does, but it triggers a crucial mechanism in the law. A complex crime essentially acknowledges that two criminal acts are so intertwined that they must be judged together. You cannot just erase the terror of the kidnapping just because the offender ultimately pulled a trigger.
Well, I come at it from a different way. I argue for the absolute primacy of the offender's subjective intent. In criminal law, we rely on the concept of mens rea, right? The guilty mind.
Sure. The mind is the architect of the crime.
Yes, and the body merely executes the blueprint. If the ultimate overriding goal is assassination, that core intent inherently absorbs the logistical steps required to carry it out. And yes, that includes the act of capturing and moving the victim.
Wait, you see the forcible taking of a human being, like dragging them away from their family, as merely logistical? That feels like an incredibly sterile way to look at violence.
I understand how cold that sounds, but legally speaking, context is everything. Think of a general contractor building a house. You don't pay the contractor separately for every single swing of the hammer or every board cut.
No, you pay for the completed house.
Exactly. The lesser actions are entirely consumed by the ultimate goal. My position is anchored firmly in the logic of People versus Camo. The court there was very explicit in its reasoning.
Ruling that the taking was just preparatory?
Yes. They held that when a victim is taken from their own house solely for the purpose of killing them, and notably not for the purpose of detaining them illegally for any length of time or for ransom, the crime is simple murder.
Simply because the killer's internal monologue was focused on death rather than detention?
Because without the specific intent to deprive liberty, the physical taking is just preparatory. It's the vehicle, not the destination. The courts have affirmed this repeatedly.
In which cases?
Well, if you look at U.S. versus Ancheta and People versus Ong, the tribunals ruled the crimes to be murder only, entirely absorbing the kidnapping. We cannot legally punish someone for the crime of kidnapping if their mind was solely and entirely fixed on murder.
I see why you think that, but let me give you a different perspective on how we evaluate that intent. You're talking about the mind being the architect, but how can we possibly look at a physical reality where a person is tied up, shoved into a vehicle, driven somewhere, and conclude, well, there was no intent to deprive them of their liberty?
Because you have to look at the immediate context.
But the deprivation of liberty isn't a theory in that moment. It is a physical action being actively carried out by the offender.
I want to lean on the jurisprudence of People versus Ramolante here to explain why the courts make this distinction. In that specific case, the victim was actively held and dragged by the offender. Visually, physically, that looks like illegal detention.
Right.
But from the moment she was grabbed until the gun reports were heard, the court noted that nothing was done or said to indicate an intention to deprive the victim of her liberty for some extended time.
But she was dragged. She was physically held against her will. I mean, that is the literal definition of losing your liberty.
Physically, yes, but the court ruled that the short interval between the grabbing and the shooting actively negated the idea implied in kidnapping. The absolute essential element of kidnapping isn't just physical movement, it is the specific intent to detain.
Right, the mens rea again.
Exactly. If someone is dragged but killed shortly after, that brief restraint is just a mechanical requirement of executing the murder. Without the distinct intent to detain, the kidnapping charge cannot stand.
I'm just not convinced by that line of reasoning because it introduces a highly arbitrary, almost absurd metric into our jurisprudence. Time.
How is it arbitrary?
Well, at what precise point does a preparatory short interval magically transform into a distinct deprivation of liberty? Is it 10 minutes, an hour, a day?
It's not a stopwatch. It's an evaluation of the primary objective.
Perfectly illustrates the danger of your framework.
The 5-day case.
Yes. A victim was taken from their home and killed 5 days later. 5 days. And yet the court held that to be kidnapping only. 5 days of profound captivity ending in a violent death, and the system gets tied in knots trying to figure out which crime absorbs which.
The Miranda-Tan case is complex, absolutely, but it doesn't invalidate the broader rule.
It exposes the flaw in the rule. By allowing the doctrine of absorption to dismiss the physical confinement, we completely dismiss the psychological and physical terror the victim experiences. The victim in those 5 days, or even in a 10-minute car ride, is suffering the profound deprivation of their personal liberty.
That is a compelling argument, and I certainly don't diminish the terror of the victim. But have you considered the ripple effects if we abandon the doctrine of absorption?
What do you mean?
If we say that every preparatory act of restraint must be charged separately as kidnapping, the conceptual boundaries of criminal law collapse. By your logic, every street mugging, where a thief grabs a victim by the collar, is now also illegal detention.
Well, that's
Every assault where someone is pinned to the ground is now kidnapping. We have to maintain boundaries, otherwise, every single crime becomes a complex web of endless charges.
Which is exactly why the law has Article 48. The complex crime framework exists specifically to handle this nuance. It doesn't say every mugging is a kidnapping. It says that when one severe crime is the necessary means to commit another, they are linked.
Right, necessary means.
Yes. I argue that dragging someone from their home to a remote, abandoned place inherently makes the kidnapping a necessary means to execute the murder safely. Think about the causality. You take them to the woods specifically so you aren't seen.
Sure.
You bind them specifically so they don't fight back or run away. That fits the exact definition of a complex crime under Article 48. Both crimes exist simultaneously in the real world.
I'm sorry, but I just don't buy that interpretation of necessary means. Let me tell you why. You are stretching the definition to include mere logistics. We have established analogies in other crimes where restraint is purely incidental, and the court do not elevate that to a complex crime.
Like what?
Let's look at the foundational logic in U.S. versus Seoul.
Oh, the robbery case?
Exactly. In U.S. versus Seoul, a group of robbers broke in and restrained their victims. They literally tied them up to prevent them from reporting the robbery while the robbers were still nearby.
Right, to secure their escape.
Yes. And the court looked at that and ruled that this was not illegal detention. Why? Because the purpose was purely to facilitate the robbery. The intent wasn't to arbitrarily detain the victims as an end goal. The restraint was a tool.
But I mean, robbery is a crime against property. We are talking about murder and kidnapping, which are profoundly personal violations. The stakes are entirely different here.
The stakes are higher, yes, but the legal mechanism, how we evaluate intent, is exactly the same. The restraint is incidental to the primary intent. Now, apply this exact logic directly to the assassination scenario in U.S. versus Ancheta.
Okay.
In Ancheta, the victim was bound and brought to a remote place where he was killed. It sounds identical to the complex crime scenario you're describing. Yet the court held that capturing the deceased did not constitute illegal detention because their purpose was purely to commit murder. The binding was just the grim logistics of the assassination.
That's an interesting point, though I would definitely frame it differently. You are isolating pure assassinations to make the math work cleanly, but the law already acknowledges that these acts can be inherently complex. Let's shift to the special circumstances explicitly recognized in our source material.
You mean the ransom exceptions?
And consequential death. Take the framework outlined in People versus Santos and Canosa. This jurisprudence establishes the special complex crime of kidnapping with murder when a victim dies as a consequence of detention.
Yes, when death is a consequence, which means the initial objective was the detention itself.
Fair. But let's take it a step further and look at ransom. The Penal Code explicitly elevates the severity of the crime when kidnapping is committed for the purpose of extorting ransom. Now, if the law can recognize this complexity when ransom is involved, or when death is consequential,
right,
it feels incredibly intellectually inconsistent to suddenly strip away the kidnapping charge just because the murder was premeditated without a ransom demand.
How is it inconsistent, though?
Because of the outcome. Why does a demand for money validate the reality of the kidnapping, but a premeditated, cold-blooded desire to execute the victim erases it? The victim was dragged from their home and thrown in a trunk in both scenarios.
It doesn't erase it. It clarifies the definitional precision of the law. I think you're conflating the physical similarity of the acts with their legal definitions. When ransom is involved, the primary intent was detention for financial extortion.
Okay.
We have to look at the specific definition of ransom found in People versus Kmata Kiran. The court defined ransom as a payment that releases a person from captivity. By demanding ransom, the offender is explicitly declaring their intent. They are saying, I am holding this person captive. There's a clear, undeniable dual intent.
And you believe a premeditated assassin entirely lacks that dual intent?
Entirely. In a pure assassination, there is absolutely no intent to hold someone captive for leverage. There's no negotiation. The taking of the victim is merely the vehicle for the murder.
I see.
If I force someone into a car to drive them to an abandoned field to end their life away from witnesses, my intent isn't to deprive them of their liberty. My intent is to end their life. The deprivation of liberty is just an unavoidable byproduct. That is why the doctrine of absorption must apply.
But doesn't that grant a truly bizarre, almost perverse leniency to the most ruthless offenders? Think about the logical conclusion of your framework.
Leniency? How so?
Well, if I kidnap someone to hold them for ransom, I am charged with a severe, potentially capital offense under Article 267 for the kidnapping, plus whatever happens next. But if I kidnap someone with the absolute intent to murder them immediately, your framework suggests I should only be charged with simple murder, magically absorbing the terror of the abduction. It effectively rewards the offender for having a more lethal initial intent. By skipping the extortion and going straight for the kill, they face fewer charges.
It doesn't reward them. Murder is still among the highest, most severely punished crimes in the land. It simply categorizes the crime accurately based on the mens rea. The law requires us to punish the offender for the exact crime they intended to commit, not a list of the physical steps it took to get there.
Even if those steps are terrifying crimes themselves?
If we ignore intent, we unravel the entire fabric of criminal liability. An accidental death would be judged the same as a premeditated one if we only looked at the physical outcome. We punish the mind that orchestrates the act, not just the physical echoes of the act itself.
Yet, as we've seen throughout this discussion, the mind is incredibly difficult to read. Courts have spent decades contradicting themselves trying to divine the exact moment an intention forms or shifts.
They certainly have.
This has been a deeply illuminating exchange, and I think it highlights why this debate is so enduring. As we draw to a close, I want to summarize where my perspective ultimately lands.
Go ahead.
I maintain that the law should acknowledge the objective violation of personal liberty as a distinct harm, or at the very least, it must be treated as a complex factor under Article 48, regardless of the murderer's ultimate goal. When a person is dragged from their home in terror, the crime of kidnapping has materialized in the real world.
Right.
To let the ultimate crime of murder legally absorb that prior terror is to ignore the physical reality of the victim's suffering in their final hours.
And I maintain that criminal liability must rigidly follow the offender's primary intent. The justice system cannot abandon the foundational requirement of mens rea just because the physical acts leading up to the crime are distressing.
Even with the physical realities.
Exactly. We must allow the ultimate crime of murder to absorb the preparatory logistics. Doing so maintains the vital legal distinction between a true kidnapping, where detention and leverage are the goals, and a murder where movement was merely an incidental step toward death.
Well, there is clearly a profound area of continued disagreement here, and it isn't just a theoretical disagreement between us, you know? It is a tension woven into the decisions of the highest courts. Conflicting rulings like the absorption scene in Camo and Ancheta, contrasted with the 5-day anomaly of Miranda Tan, perfectly showcase the immense difficulty of balancing physical acts against psychological intent.
They absolutely do. It proves that the law is not a static monolith. It is an ongoing, sometimes messy attempt to map the darkest, most complicated facets of human behavior.
There is immense value in analyzing these tensions. Understanding how the justice system struggles to categorize the deprivation of liberty against the ultimate deprivation of life really shines a light on the intricate complexities of the Revised Penal Code. We highly encourage our listeners to dive into the source material themselves.
Yes, explore the jurisprudence.
Exactly, and form your own conclusions on where the line should be drawn.
Because the deeper you look into the case law, the more you realize how delicate the balance of justice truly is when trying to read the human mind.
Indeed, we want the law to be a clean, precise schematic. But when you are charting the distance between the moment a person loses their freedom and the moment they lose their life, the lines will always be drawn in muddy waters. Thank you for listening.